Good afternoon. Welcome to the Fayetteville Public Library. My name is Kathy, and I'm with the Adult Reference Services. I'd like to point out that there's a table in the back that has some flyers on it from upcoming programs and our monthly calendar. On the tables in front of you, you'll see there's a questionnaire. If you'll fill that out after the program, it does help us with future programming. Today, we have Katie Burns, a local licensed attorney. Katie will provide real-life examples to explain probate, wills, trusts, powers of attorney, and more. And bring any questions you have, and Katie will provide the answer to them at the end of the presentation. Thank you so much. Let's welcome Katie.
Hello. Thanks for coming. I've given notepads and pens. If you have questions, write them down as soon as you think of it, because you'll probably forget by the time we get to the end. This should not take too long. I'm going to hit a lot of high points because, with this estate planning stuff, there are a lot of moving parts, a lot of, fact-specific things that'll be different for every person. But I'm happy to answer questions at the end. If you cannot hear me, stop me. I'm going to try to talk slowly. I like to get ahead of myself sometimes. Hang on, let me figure out how to work this thing. So just a little bit about me. I went to Arkansas Tech University in Russellville for my undergrad degree, and then I went to William H. Bowen School of Law in Little Rock for law school. I'm originally from South Arkansas, and so Little Rock was closer to home. You can probably hear it in my accent a little bit. I have been with Arkansas Asset Protection Group since May. I was at a law firm for 6 years prior to being with this law firm, and we only did estate planning. Arkansas Asset Protection Group has been around since about 2011. We are all across the state. There are 3 attorneys for the firm, me and 2 others, and then just a ton of people that help support and do kind of back office stuff for us. We do this estate planning stuff that I'm going to talk about today. I'm going to touch very briefly on long-term care Medicaid planning, right? So if someone's going into a nursing home, we do a lot of what we call crisis Medicaid planning. So if somebody's going into a nursing home, how do they pay for it? How do we navigate all of those things? So that's the bulk of what the firm does. I love this stuff. I love the estate planning. I love solving the problems, hearing a fact pattern and going, okay, these are your goals. This is how we can make this happen, right? So I do some of that Medicaid stuff, but this is what I like to do. I've been married since 2022. No kids, but I have a 140-pound giant schnauzer named Hank that I probably should have put a picture on here of, but I forgot. Okay, so just kind of starting from the beginning, people hear the term estate planning and what does it mean, right? So I'll hear all the time, oh, well, I'm not old enough to do estate planning, or I don't have enough assets, right, to do estate planning. Really, estate planning is just how do we manage and control what happens if you can't make decisions for yourself, right? And then what happens when you pass away? Where does everything go? What's that going to look like? And it makes sure that you're honored, your wishes are honored. Because we have a lot of people that go, oh, well, I told so-and-so that this is what I want to happen with my stuff, and I trust that they're going to do it. But sometimes there are nuances in there that prevent that from happening, right? With estate planning, I always tell clients that we are planning for the worst, and we're hoping for the best. Because if I've planned for every bad situation that I can come up with, then I've potentially protected in all those different areas, right? So these are just a couple of to add on to what I just said. Estate planning keeps things out of probate, which everybody hears probate's bad, we got to stay out of probate. Probate is the bane of my existence. I have a bunch of probate cases and all of them give me a headache, right? We absolutely want to stay out of probate. We want to make sure that our loved ones are taken care of, right? Whether that's a kid with special needs or somebody that can't manage money or just making sure that the money's still there for a surviving spouse, things like that. We want to look out for minor kids, and we want to make sure that in situations where you can't make your own health care, or financial decisions. We know who can make them. We're not in a crisis mode of trying to get someone named when the crisis happens. So we want to do all this stuff, before it's too late. So these are just some key components of an estate plan. We do trusts. There are 15 different kinds of trusts that are used for different, reasons. There are wills that everybody hears about. Powers of attorney, which is what allows somebody to have the authority to make decisions for you if you can't. The healthcare directive or the living will, that's something if you've been to the doctor or had a procedure in the last 5 years, one of the first questions they're going to ask you is, do you have a living will? Do you have an advance directive? We can thank COVID for that. And then beneficiary designations on assets is another, component of estate planning. If I'm moving too fast, y'all tell me to slow down. I see some of you writing things down. So a will, I'm going to kind of differentiate between some of these documents, because growing up, everybody hears, oh, you got to have a will. You got to have a will. You got to have a will. I would say in the last 5 years, I have probably done maybe 5 wills for people. And that was a specific situation where, I had a 30-year-old couple that had 1 kid and they had 1 bank account, and we used the will to nominate a guardian for the kid if something happened to mom and dad, right? Wills do not keep your estate out of probate at death, and that is a huge common misconception. I hear that all the time. Well, I have a will, it'll be fine. The will still has to go through probate to be enforced. Wills can be updated, so that's a plus, right? Some people go, oh, well, I can change it as many times as I want to. You can. And it is going to dictate how your assets are distributed at your death. Trusts stay out of probate. There is, I don't want to use the word never, but there's very rarely court supervision of a trust. It depends on the type of trust and what its purpose is and all those things. But there are different types. There are ones that you can change, and there are ones that you cannot change once you've executed them. They can help asset management during your lifetime and when you're gone. It's not public record. So probate, as soon as I file a probate, we know what the assets are. We know who the beneficiaries are. We know everything, and the whole state can look it up online and see it, right? Trust provide the ability to plan for the what ifs. So when I talk about planning for the worst and hoping for the best, I can go, okay, well, if this kid is married to this person, when you pass away, do you want that person to get a share, or do you want it to skip? Right, there are all these different scenarios we can work through in a trust that I can't necessarily do in a will. And they can be changed at any time if they're revocable. So powers of attorney, you've got financial POA that, when it's in effect, generally allows someone you've appointed to do anything with your finances that you can do. They can buy and sell a house, under your name. They can empty your bank account. They can help pay your bills, right? Healthcare is, if you can't make a healthcare decision, they're going to make the decision. Yes, do that surgery. No, don't do that surgery. They can hire and fire doctors, things like that. If you see a document that says it's a durable power of attorney, that means that it's still in effect even if you become incapacitated. Some powers of attorney are specific and say, I give that person the authority to only do this one thing. While I'm, still with it, I'm making it effective now. This durable power of attorney means even if you sign it today and you become incapacitated tomorrow, it's still in effect, and so it stays through the time of your incapacity. Long-term care planning. When I talk about long-term care planning, I'm talking about someone's in a nursing home and we've got to do some things to qualify for Medicaid or whatever we're trying to do, and we need a power of attorney to be able to do those things on your behalf. Healthcare directives. So HIPAA, I'm going to start with HIPAA. HIPAA, every time you go into a doctor's office, they probably hand you a form that asks who you want to be on there. You have to do it every time. We do general HIPAA authorizations so that they're always with the healthcare power of attorney document, the living will document, so that when you go hand it all to your doctor has everything they need, right? But that's who they can, whoever's named on there is who they can release information to, and speak about, your health situation. The living will, it's also known as an advanced healthcare directive. I want to talk about this one for a second. A living will is, right, an end-of-life document. The example I always think of is hospice care. You can't make decisions for yourself, right? You're unconscious. And there are options on life-sustaining treatment, which would be a ventilator or dialysis or whatever, right? This is a different document than a DNR that I hear a lot of people get mixed up. So a DNR is you've had 6 heart attacks and you're done. You don't want any more stents. You don't want them to resuscitate you if you have another one, okay? That is a form that has to be signed with your physician because you have to be really informed on, hey, you signed this, the EMT can't resuscitate you, okay? That's a different form than this living will that I'm going to talk about throughout today. That's just a really important distinction to make because people get wigged out because they think that this is a pull the plug term. I hate to use that term, but that's what people call it. This is not a, you sign a living will, they're still going to probably hit you with the paddles and pump your chest and things like that, right? Beneficiary designations, typically on life insurance, retirement accounts, you're always going to have a designation that says who the beneficiary are or is. Cash accounts, so like bank accounts or checking account, they're going to call it a payable on death designation. A brokerage account, they're going to call it a transfer on death designation because it would make too much sense for us to call it all the same thing, okay? But they all function the same way. So all these different accounts, you can use beneficiary designations. Beneficiary designations keep that asset out of probate because it's going to go directly to the person that's named, right? Okay, so I'm going to kind of walk through a scenario, and I don't want to get too in the weeds on these amounts necessarily, but I'm going to kind of walk through what a scenario would look like with just a will if we had done a full plan so you can kind of see the differences and how things would play out, okay? So let's assume that John and Jane have been married for 40 years. They have 3 adult children, Jack, Jill, and Jacob. They've got a house that's in both of their names. They've got 2 vehicles that are in both of their names. They've got a checking account, same thing, both of their names. Total, they've got some retirement accounts that equal about $300,000. And it's a mixture of IRAs, 401ks, 403bs, things like that. And then just regular brokerage, stock investment accounts. And some of these are going to be in individual names, right? So an IRA will never be in your spouse's name. It's always got to be one of you. Okay. So let's say John and Jane have wills that they had done 30 years ago because they were trying to hurry up and leave the country on an anniversary trip. If I've heard this story once, and with clients, I've heard it 1,000 times because it's always that, hey, I'm going out of town and just realized I didn't do this, right? So somebody 30 years ago drafted this will, and the kids were young when this will was done. But now Jack's married. He's got 2 kids. He has a good job. He's financially responsible, and he lives close by. Jill is divorced. She's got 1 kid. Owns her own business, so she's financially responsible, but she lives 3 hours away. Jacob has never been married. He can't keep a job, maybe has a drinking problem, but he's an hour away. Okay, so those are kind of think of our 3 kids. These are our fact pattern. John gets diagnosed with dementia. Okay, he's still really early on. He still has enough cognitive ability to make some decisions. So he could still sign documents that say who his financial or healthcare power of attorney would be. So what does it look like as far as Jane's ability to care for John at this stage? Nothing's really going to change because both of their names are on bank accounts, they're on vehicles, they're on the house together, right? And he can still make some decisions. So if she needs to just pay the light bill because he, is asleep and can't go get the checkbook, she can do it. So right now, she's not having to make decisions on his behalf. She's just still managing things as if everything's okay, okay? But after about a year of that, John gets to where he can't drive without getting lost. He can't keep his medication straight. Forgets to send the light bill in. And so Jane has really had to step in as a full-time caregiver. They're at doctor's appointments and conversations are coming up about care plans, meaning, okay, what are his intentions? So on a living will, what kind of life-sustaining treatment would he want us to give? If he does pass away, what does he want to be buried? Does he want to be cremated? John can't make any of these decisions for himself at this point, and so they've started asking Jane for these healthcare directives because they need to be able to know that whatever decision she makes, she has the authority to make, and they're not going to get sued because, right, it all becomes a liability, okay? So with their current plan, the estate plan, all they had were the wills from 30 years ago. There were no health care directives in place. And now John does not have the mental capacity to execute the documents that they needed, like the power of attorney documents, because they didn't do it when he still had the cognitive ability to understand the documents, right? So now her only option, in order to be able to make those decisions for John, is to go through a legal adult guardianship. So we're going to walk through what that looks like. So a guardianship is a court case. So again, it's public, and we file it, and we say, hey, this person can't make decisions for themselves. We typically have their doctor write a letter or testify saying, hey, this person definitely does not have the ability to make these decisions. And then a judge decides who the guardian's going to be. Typically, it's a spouse, but it could be a situation where spouse is in not much better shape than the person needing the guardianship is, right? And so then it might end up being one of the kids. Well, do we know that the judge is going to pick the right kid to be the guardian? Because when we establish guardianship, we're now naming a person that can make all healthcare and financial decisions. And we've lost some control because the judge is going to make the decision at the end of the day. So let's back up, and let's say that they updated their estate plan from 30 years ago, and they have a comprehensive plan now that's got a trust, it has a will, and I can go into a little more detail in a little bit about how wills play into trusts, but we've got the power of attorney documents, we have the healthcare directives, we've talked about all the things. So now, how is this going to help Jane if John can't make his own decisions? So now, when they're in the doctor's office and the doctor says, hey, did John have a living will? She's going to go, yeah, here it is. And she's going to have it, and they're all going to be on the same page. And John is going to be able to be advocated for immediately in the best way possible right then, because we know that he wanted Jane to make those decisions, right? We get to avoid the guardianship. One thing about guardianship, too, that I want to point out is it's not fast, right? So in that moment, if those healthcare directives were already established and we handed them to the doctor, we get to move forward. If we have a guardianship situation, right, even in an emergency guardianship, we're still waiting and hoping that the judge isn't on vacation, or we're hoping that the attorney can get the documents drafted in a timely manner. And in the meantime, somebody might need to make a decision for John, right? Because these things are not, sometimes time is of the essence, right, with some of these medical situations. And so with guardianships, we kind of roll the dice and we're at the mercy of the court on a time frame, which is not always in our favor. And the judges do not do it on purpose. It's just how the cookie crumbles sometimes. So eventually, John's dementia progresses and he's to the point where Jane can't keep him, at home. She can't keep being the full-time caregiver. He needs around-the-clock care in a skilled facility with trained professionals, right? So John moves into a long-term care facility or a nursing home. We know that Jane is the one that is making all the decisions, can act on John's behalf, can sign documents, can do all the things. But how's she going to pay for it? Okay. On average, I would say in Arkansas, Northwest Arkansas, it's a little more expensive, but the average cost of 1 month's nursing home in the state of Arkansas is probably somewhere between $6,000 and $7,000 a month. My grandmother-in-law is in a facility, and hers is $9,000 a month. So when you stop and you think about the assets and the amounts that I had spelled out in this scenario, at $9,000 a month, right, People with dementia sometimes can live another 10 or 15 years in a skilled facility because they're getting consistent, good care, right? So at $9,000 a month, the money is going to start running out. And so then we kind of have to go, okay, how can we make sure that Jane is not left destitute? How's she gonna pay for John's care? Okay. Well, I got ahead of myself. So one note about the end of this slide. There's private pay and there's long-term care Medicaid. So private pay is you're going to use your own assets to pay the nursing home every month, right? Long-term care Medicaid, when you meet the requirements, will step in and they pay the nursing home. The Medicaid policy manual has things in place, and there are things that you can do to save some of the assets instead of spending everything down on the one person's care and leaving the spouse destitute, right? Again, I'm getting a little bit ahead of myself. I'll talk briefly, and I'm happy to answer questions about Medicaid. I'm not going to get too in-depth on the Medicaid thing in this slide, or in this PowerPoint, because there are a lot of moving parts, a lot of really specific rules. I'm happy to do another presentation on just Medicaid, but it's important to note how the estate planning can play into when we get to this long-term care situation, because I hear all the time too, oh, well, I'll never put him in a nursing home. That's never going to happen until you realize that you're not qualified to care for the person, and you can't adequately be the caretaker that they need. To start out, let's say Jane's spending everything to pay the nursing home, but once she's used all the money, then she would qualify for Medicaid. And in a married couple's case, it's not very much money that they get to keep, not very much income they get to keep. So she would basically be destitute, right? Before long-term care kicked in to pay for John's care. So then, but what if there's another way? You call us, or you call somebody that does this long-term care. We call it crisis Medicaid planning, because this is somebody had to go into a nursing home yesterday. And one of the most common scenarios we see isn't always necessarily, it is dementia. Dementia is one of the most common. But another one is, hey, mom went in for hip replacement and she's just not, she might stay in the rehab for, the 6 weeks or whatever, but she's just not, I don't think she's ever going to be able to come home. That's the call we get the most often. And so then at that point, they're in crisis mode because they're going, what do we do? How are we going to pay for it? I don't understand how to navigate this. And so this is where people just don't know that things like long-term care Medicaid exist, because they'll get to the facility, to the nursing home, and they'll start getting advice from the nursing home that they know just enough to get people in trouble, right? Because there are very particular rules about how long-term care Medicaid works. So at this point, just to kind of bring us back to the scenario, let's say that John had to go into a facility, but Jane called us, we saved a bunch of the assets, got him qualified so that she still has money to live on, right? Okay. So now, let's say that John's passed away. So what changes and how is the scenario affected here? So once John passes away, the power of attorney documents are null and void. They're not helpful anymore. Power of attorney documents are only worth anything while the person's still living, okay? And now we have to go through and look at every asset and see how it was titled, who owns it, does it have beneficiary designations, things like that. So we know that the house, the checking account, vehicles, and investment accounts were owned jointly. So Jane will continue to control those and do what she needs to do with those accounts, okay? Jane was the primary beneficiary of John's retirement accounts, so those are going to pass to Jane. So we don't have to have a probate. But let's say that if they had only had the wills from 30 years ago, and then we'll look at it from the other side if they had done the comprehensive plan. So with just the wills, the will in this situation is irrelevant. They paid somebody money however many years ago to draft this will that we're never going to use because there were beneficiary designations on everything. So it's all going to stay out of probate, so there's no need to submit the will to probate, okay? My biggest thing when I tell people, they're like, oh, I need a will. If you really want me to draft a kind of expensive piece of paper for us to never use it, I will, but I try not to, right? Because the goal is to not use a will, because that means we had to go to probate. Does that make sense? All the assets were owned jointly, so she's gonna keep functioning like normal, and the will itself is not gonna keep us out of probate. If they had drafted the comprehensive estate plan, again, she's gonna retain control, okay? So in those two situations, we're okay. If, for whatever reason, one of his retirement accounts didn't have a beneficiary designation on it, which I have seen happen if they change companies or something like that, and the new company doesn't put a new beneficiary designation on it, then that asset would have had to have gone through probate, just that one. And then we would have had the will that says, hey, it goes to Jane. But in the meantime, we would have had the court costs, the attorney's fee, a 9 months probably waiting time before she ever saw the money, things like that, right? Okay, so then 5 or 6 years later, Jane passes away. So what's it gonna look like for the kids? Because this is typically where people go, okay, well, I don't care what happens to me, I wanna make sure the kids are taken care of, okay? So the wills from 30 years ago, they each named each other as executor, right? Because the kids were minors. So they named Jane's sister Jenny to be the executor or the administrator of the will. But Jenny's older than Jane was. She lives 8 hours away, hasn't spoken to any of them since the great fallout of Christmas 2005. If I've heard that story one time, I've heard that story 1,000 times. It happens. It just does. So now we've got somebody that hasn't spoken to the family since 2005 that's going to be the executor of this will, and she's not entitled, right? She's not a beneficiary, okay? So why would she stay in the middle of it? So we're going to go to probate because after John's death, everything went to Jane's name, right? But then Jane didn't go back and put new beneficiary designation. She didn't update a trust. She didn't do all the things that needed to be done. So we're going to say that the retirement accounts are still going to go to the kids outside of probate because they were contingent beneficiaries. So just kind of, this is a side point. I probably should move this up in the presentation, but probate, I tell people on a good day, it's 9 to 12 months to get through the entire process. Because there is a required 6-month time period in Arkansas from the time you publish it in the paper to let creditors make claims against the estate, even if we know there aren't any, right? So this could be medical debt, it could be credit card debt, it could be somebody you signed a contract with, right, that's trying to get money from the estate. So we have to wait at least the 6 months before we can do anything, before I can distribute anything. Sometimes I can sell a house if I need to with court approval. But it takes a minimum 9 to 12 months to do a full probate. There's attorney's fees, there's the executor's fees, there's court costs, publication costs, things like that. In Arkansas, there's a statute that determines attorney's fees, and there's a statute that determines the executor's fee on what they can take. So just to kind of give you an idea of what probate will cost. So, and attorneys, we can contract for, more or less than the statute based on the complexity of the case. But if we were just going to use the state statute, I did a probate about 3 years ago. There was one kid, there was one house, sold the house for $450,000. Which in Northwest Arkansas, it doesn't take much for somebody's house or property. It can be worth $200,000 one day, and somebody buy it, the Walmart Foundation buy property next to it, and then it doubles or whatever. But the fee on that one, and just for reference, I did not take this fee because I didn't do that much work, but the statute said that I could have taken $15,000 as my fee for doing the probate, and it was one house and it was one kid. That's how expensive probate is, okay? And typically, when I do the math and run it through the statute's formula, the executor's fee comes out higher than my fee is. Okay, so keep that in mind when I'm about to talk about Jenny here in a second that's going to get to do this probate. So even though Jenny's not a beneficiary, why would she walk away from being named the executor in this probate? Because depending on, we've got the $300,000 house, we've got the bank accounts that need to be probated and the investment accounts, she's going to have an executor's fee. So if I'm Jenny, right, it sounds like clearly they didn't get along. She's probably going to go, oh, let me get my, my little piece of this. The will does leave everything equally to the 3 kids, but the will is just going to leave everything to those 3 kids outright. It is as simple as we cut a check to each kid and they walk out the door with it, okay? So for some people, that's fine. For some kids, we don't need to hand them a $100,000 check, right? They're not financially responsible enough. They're not old enough. There are other contributing factors like, substance abuse or whatever we need to consider. I always think about this, that money, when we give it out in a probate situation, it's like squeezing the toothpaste out of the tube. There are things doing this that I encounter in hard situations that I'll never forget, and one of them was handing an active drug user a $55,000 check because I had to, right? He was on drugs when he came in to pick it up, and by law, I had to hand him the $55,000 check. That'll make you kind of go, hey, let me rethink some things, because we didn't do that kid any favors, right? We know exactly where that money went, but there's nothing I could do about it, because his mom had not done estate planning to prepare for that, right? So other point of view is that they had done the comprehensive estate plan, and everything was taken into consideration. They had done a trust. Everything had been put into the trust. So when they passed away, the trust, think of it as John and Jane owned the trust owned the assets, and the trust said what happened to the assets when they passed away, okay? Let me back up real quick too. So with beneficiary designations, typically when I do a revocable trust, and I want to say, okay, all the assets go to this trust, this is how everybody gets everything, I don't use beneficiary designations to individual people very often because, again, I can't control it, right? So even on like a brokerage account where I could say, hey, make the beneficiary the kids because that's who I want it to go to, I'm squeezing the toothpaste out of the tube and I can't get it back in. What I would use beneficiary designations for in a trust situation is we make the trust the beneficiary. So at death, the money is going to funnel into a trust account that our named person is going to control. And then it says, hey, this kid gets $500,000 a month, or $500 a month. Well, I wish I got $500,000 a month. Right, I can control it without squeezing it out of the tube, right? So instead of the individual being the beneficiary, we would use the trust, and then the trust would dictate how and when and who and where, right? So this trust, we can talk about all the different concerns. So we don't think that Jacob should be given a lump sum, right? We think we can give him an allowance. We want to make sure that he can still pay his rent and he can buy groceries and he can whatever, but we don't want to give him too much money that we're just giving him the rope, right? Jill's divorce. If I've heard this one, I've heard it 1,000 times. And we don't like her new significant other. People come in and they feel ashamed because they'll say, I don't like my son-in-law. That's the first thing they say to me. Not many people do, right? I mean, that's what I've gathered. And so, their concern is how do we make sure that, if something happens to her, that her spouse doesn't end up with what we worked for, right? With Jack, with having 2 kids, we want to make sure that Jack's kids would get his share if something happened to Jack. With the trust, we can control it all the way down. And there's a fine line between controlling from the grave and setting people up for success. We want to put them in the best position to be able to make good decisions and, do right by their kids and all those things, with the things that you worked your entire life for. So now with this trust, we've given, Jacob $500 a month, and we've written it in there that if something happens to Jack, that his kids get it. And maybe we let Jack's wife control the money for the kids, but she doesn't get to go use it when she gets remarried or whatever. We were able to name Jack as the trustee of that trust or the executor of the trust, and we got to keep Jenny out of it because she doesn't need to be involved, right? So we fixed all of those problems. So, and I know I've kind of hit some high points. There are so many moving parts to estate planning that people don't realize until we sit down and we start talking about it, and I ask a question and they're like, oh yeah, no, I haven't thought about that. Because you're not living your life planning for the worst, hoping for the best. That's what you come in, and I have to be the one that asks those hard questions, right? But the lack of proper estate planning before John's death. So the way that I kind of think through some of this, after death, we can get everything administered. We can do what we need to do. It might not be ideal. We might have to go through probate. We might have squeezed the toothpaste out of the tube, okay? That's hard. It's bad. We can fix it. The lack of planning in a crisis situation where someone gets a dementia diagnosis or, we have an accident, things like that, that to me is where people miss the importance of this. Because that's a different kind of crisis mode, because you're still actively trying to advocate for someone. And we all know what that's like in a doctor's office, right? We're still actively trying to follow this person's wishes. And specifically, I keep using dementia because it's one of the most common situations I have, but you're also trying to maintain that person's dignity in the middle of it. And so sometimes what I find with dementia diagnoses specifically is it's not that the person is incapacitated or just absolutely can't make decisions. It's that they need help. But because they don't have these powers of attorney in place so that kid can come in and help pay the light bill or handle what they need to handle at the bank, short of having that person deemed incapacitated or incompetent, nobody else can help. Well, now we've run into a dignity issue because that person still, is with it. They just need some help, right? And so this isn't always just about planning for death, because at death, even if I have to go through probate and I have to go home and gripe to my husband about it because I don't like probate, I can still get it executed and we can get it to the end, right? Guardianship is not something that you want to have to get in the middle of when you're actively trying to advocate for somebody in a health crisis or health situation, right? You want to be able to make those decisions right when they need to be made. So just a comment, and I'm getting close to the end here, but just a common list of mistakes that are made. Procrastination. People always say, oh yeah, that's on my to-do list. I'm going to go get that done. Right? People avoid it because it's hard. You have to think about hard things. You have to make hard decisions. You have to face some family truths sometimes and acknowledge some things that you kind of want to avoid. But I tell people, my best friend, she does criminal defense, and she asked me one time, how do you do this work? You talk about death and dying and sickness all day, every day. And I said, yeah, but I can fix it, right? Like I can make the plan, put it in place, and I know what's going to happen, right? You're defending people that don't know how the marijuana got in their pocket. We're very different people. But the putting it off is one of the most common mistakes, because even if all you have is a checking account, putting a beneficiary designation on it is estate planning, and it needs to be done. I have probated safety deposit boxes that were empty, that we didn't know they were empty until I had court approval to get inside of it, right? You don't want to pay me to probate an empty safety deposit box, or one that's got, a document in it that is, that account went away 20 years ago. I've seen that too. Another mistake is people fail to update their documents. So, people go, oh yeah, I had that will done 30 years ago when your kids were 9 and 12. The thing about estate planning, revocable trust specifically, they change as your situations change. I have clients all the time, clients that have lost kids. That's not how that's supposed to go. We have to regroup on the plan. We've got to change what the documents say. This is something that'll probably ruffle some feathers, but adding kids to owners to your accounts, I always advise against, because here's what happens. If you have a bank account with $50,000 sitting in it and you go, oh, I'm just going to put my daughter's name on it so that she can write checks on the account and all that stuff. And if you get that statement and her name is on that statement with your name, she's an account owner, okay? And if your daughter runs through a red light and hits a school bus full of kids and she gets sued, your money looks like it's her money, and the first place I'm going as a personal injury attorney is to liquid cash money, right? It's a liability issue. If you want to put your kids on as an authorized signer, that's different, because that just means they can write a check, okay? But if you've done your estate planning and there's power of attorney in place, they could use the power of attorney at the bank without having to actually ever put their name on the account, okay? But that gets people in some risky situations, because even if you trust your kid and you're not worried about them emptying your bank account, that isn't the point. It's the unknown, it's the things we can't control, and we don't want it to come back and bite us, okay? A common mistake is spending all your money on the nursing home. People think there's not any other option. They get to the nursing home gives them bad advice, and they just keep writing checks until the bank account's empty. When really, even if we saved a month's worth of nursing home, I don't know about y'all, but $9,000 is a lot of money, and I could do a lot of damage in a purse store with $9,000, okay? So people just need to know there are firms, we're obviously one, but there are firms that do that kind of planning. You got to call and get in there and talk about it and see how they can help you. Don't spend all your money. Don't just keep writing the checks and then go, oh, well, I'm out of money, because there are things we can do. Another mistake is not communicating things to your family. One of the documents that we do is a document that can say, I want to be cremated, or I want to be buried, or whatever. Those are not fun conversations, even if you write it down somewhere for somebody to see. The reason I ask people this is to force them to talk about it. I have sat through so many appointments where I'll ask this question, and husband will say one thing, and wife looks at him like, oh, I didn't know that, right? I would have buried you because I didn't know you wanted to be cremated, right? So that kind of stuff is important, because 90% of the time your loved ones are going to do what you want them to do, right? It's even if you never sign the form that I give you to fill out, if at least you talked about it, you've put your loved one in a better position than they were had you not talked about it, right? So I kind of talked about this. So getting started, obviously call us. If you're going to do estate planning, go to an estate planning law firm. If they're also unless there's some massive firm and they have an area dedicated to estate planning, if they're also taking divorces and DWIs and all that stuff, they're probably not paying as close attention to some of the details of this estate planning, and they'll probably let you walk out with a will, and you won't have what you think you're going to have, right? I have had clients walk in with a trust that was 3 pages long. I can promise you that a trust that's 3 pages is not going to accomplish the things that you thought it did when you walked out of there with it, right? Some of these decisions that you have to make are hard. I have clients all the time that I'll ask a question, and I know that they're going to have to go back and think about it. They're going to have to talk about it because they've never thought about it before. But when you're done and you know that you've done everything you can to make things easier for your kids, I saw this quote one time that said, estate planning is not about you. It's not for you. It's for those that you're going to leave behind that are going to have to navigate it. One of my the most negative things to me about probate is sitting across the table from someone who's paying their own mortgage, has their own bills to pay, and then mom passes away with a mortgage, right? And now everything's locked down. The bank accounts are locked down, all of it, and they're trying to figure out how the heck they're going to pay their mortgage and mom's mortgage because it's locked up in probate, right? And in the meantime, I'm calling the bank trying to get them to not foreclose because I'm trying to get it through probate, right? That's a different level. You're trying to grieve, and you're also trying to figure out how you're going to pay the mortgage, right? So it's things like that you want to get ahead of if you can. Okay, I think we're kind of at the end. Yeah, do any of you have any questions? And I'll stick around if you don't want to ask in front of anybody. Yeah?
One of you already have Medicaid.
So,
You go into a nursing home.
yeah.
Is there any way you can get where you can put money back ahead of time with whoever's going to take care of your needs? Where they can give you a little money or they're.
Can have it. So that would be, and this is going to be a classic attorney answer, and I do not mean for it to come across like this, but it depends, right? That would be something that we would sit down and I would ask you 1,000 questions about your current situation that are very specific to you.
Let's say you don't have a lot of money, but you might make some
So if you think you're gonna make money, it's possible. With long-term care Medicaid, you know, people always hear about that 5-year look-back rule. That's gonna come into play, right? So how long the 5 years has been, all those things. So, it's possible is the answer. We would just have to sit down. I would have to know all the specifics. One thing I want to mention too, so if it's something that you feel like we need to meet, all of our consultations are free. So, because that just allows me to sit down and really hear, because I don't want to give you bad advice because there's one thing that is important that maybe you don't know is important. So I would say to you, the answer is it's possible. We would just have to look at it and see. Okay? Yeah.
You mentioned regularly updating the state planning documentation.
Yeah.
I understand it's not the first thing that comes to mind when there's a major life change.
Yeah.
So how often would you recommend that you?
So I tell people 3 to 5 years or major life events, right? And it's not, right? Death of a spouse, obviously, well, I would say it's not obvious. I have clients that I've worked with for years, and spouse passes away, and I'm one of the first phone calls because they're going, okay, what do I do next, right? And I bring them in the office, let's sit down and talk about it. I have some that wait until a year has passed. Typically, what I would do with existing clients is if they call and say, hey, so-and-so passed away, I would pull the plan, look at it, and say, hey, I don't need to see you for 6 months, or like give yourself some time, right, and then come in. But 3 to 5 years is a good window because especially for younger people, in 3 to 5 years, your financial situation has probably changed to some extent. Depending on your age, we've added kids. Kids are out of the house now. Because if you try to get me to put an 18-year-old as being in charge of your trust, I'm probably going to try to talk you out of it. But you come back 3 years later and they're 21 and they graduated from college, or we know that they're financially, maybe we talk about it then, right? So 3 to 5 years or major life events, which could be, you know, deaths, marriages, births, significant financial changes, things like that. Yeah.
Is a living trust pretty generic, and what I mean by that is, do you have to specify a certain address for a home you own, and then what if you move a month later?
Yeah.
Or you sell a vehicle and get a different one?
Yeah, that's a good question. No. So what would happen with a house specifically is, and there are some nuances. So let's assume you've got a house with no mortgage on it, okay? Because mortgage companies add a little bit of a kink. But we would put that house in the name of the trust. So your tax statement would start coming up and it would say the Jane Doe Living Trust, okay? If you sell that house and you buy a new one, we're going to tell you to buy the new one in the name of that trust. So the trust document itself is not going to say, hey, we own this house at this location and this is the only house it's ever going to own, right? The trust, think of the trust as kind of think of it like a shoebox, right? Okay. And we put things in it, we can take things out too. We move things in and out because people will change banks. They'll open new bank accounts. And so it doesn't have to change the document itself, right? As long as the terms of who gets what and when they get it and all that stay the same, we would never have to change the trust document. But with all your assets, it just comes and goes as you need it to. Does that answer your question?
Yes.
Okay.
I have another question.
Yeah.
I know this might be difficult to answer, but what is the average cost of a living?
So that's another attorney answer. It depends, right? I don't usually give numbers in settings like this because it absolutely depends on the person, right? Because there are people that come in telling me, hey, I need a trust, and by the time we're done, I don't think they do, right? I don't think there are cons to having a trust. Trusts are usually a little more expensive to set up on the front end than a will would be, which is why some people they go back toward the will option, even though it's going to cost the estate on the back end in probate, right? I think that with trust these days, from what I've seen from other ones that have come in my office, you get what you pay for. I think that if you get away with paying $1,200 for a trust, your trust is not going to accomplish the things that you think it's going to accomplish. If that kind of gives you, I don't know if that gives you a ballpark, but, I've done trust for $9,000 before that included special needs terms because it depends on how complicated it is. I wouldn't say it depends on how much money it is because I can direct money the same way in the trust, whether it's $1 or, $1 million. But that's something, when I meet with people, we go through all the stuff, answer all the questions, kind of get a plan, and I would tell you before you left, hey, this is what it's gonna cost. We don't send people bills that they don't know what it's gonna cost and things like that. So, I would say, you're looking in the few thousand ballpark for most trusts, and what we're trying to accomplish. Talking about, that question she asked about putting money aside, right? An irrevocable trust is a little bit more complex of a situation. It has some permanency. There are some different rules and provisions that need to be in those. Those are gonna be a little more expensive than just a living trust would be. And again, very rarely do I do just a trust. If I'm gonna do a trust, when you leave, you're gonna have power of attorney and healthcare directives and all of it, right? By the time you leave my office, I wanna make sure we know what's coming from every direction. So I know that's a really around the bush answer. But we are.
That helps a lot.
Yeah, it really is just hard to give hard and fast, numbers.
500.
Yeah, yeah,
Yeah, no, it helps
Yeah.
adjust my thinking.
yeah, and one thing, and I see you, I'm gonna get to you in just a second. One thing I wanna note too, is people will say, oh, well, this attorney is gonna charge whatever, I can go online and do it. Please don't, please don't. I have cleaned up so many messes on the back end from people that thought that they were doing the right thing. So I'll put them on blast. LegalZoom is one that is popular. You see advertisements. They have a disclaimer at the bottom of all their stuff that says, hey, we're not giving you legal advice. We're not certifying that the things we're telling you in the plan we've put together is accurate for your state. And that's the thing of all those little nuances, especially when it comes to your property, land and things like that, that LegalZoom can't take into account because you don't have the one-on-one, attorney that's telling you, hey, if you do this, this is how this is gonna play out. So I would also be very weary of those things too, just to save cost, because what happens is people do them and then they end up in my office redoing them, right? Okay, yeah.
So you kind of already touched a little bit on it because it's kind of all
Yeah.
together. My question actually had to do with basically the estate planning and the trust with assets that are in different states.
Yeah.
So, can you explain a little bit about how something like that would work? For example, like my father left me property in a
Yeah.
different state that I live here in Arkansas.
Yeah.
How do I incorporate it?
Yeah.
Into my trust, basically.
So the trust has what is called a situs, that's where it lives, right? Think of the trust as an entity, and it exists in the state that you reside in, right? So if you have a piece of property in Texas, I'm gonna find a Texas attorney that'll draft a deed, because I can't practice Texas law, and we're gonna deed that piece of property into the trust, and then at your death, the trust says who gets it. We'll probably have to hire a Texas attorney at that point to distribute, for another deed. But the trust can own property from wherever. If we get into international assets, that's a little bit different of a ballgame, because every country handles their distribution differently, right? They may not have a beneficiary designation. Some countries, it doesn't matter. It's absolutely gonna go to spouse, even if they didn't want it to, right? So international stuff's a little bit different, but within the state, and if it's Louisiana, we're gonna have to hire a Louisiana attorney, because they practice a completely different kind of law. But, pretty much any other state, no problem. Your trust here can still own it all.
Any property, even, if we owned 10 rental properties in this state, that would basically filter the deeds into the trust.
Yeah, so I will make this point too, and again, this is why I say there are so many moving parts to estate planning. If you walk in my office and you tell me you have 10 rental properties, we're gonna put it in an LLC, right? And then the trust is gonna own the LLC, because I wanna limit liability, because if somebody breaks their neck on your rental property, I don't want them getting to your house, right? We wanna separate some stuff out, so, but yes, the short of all that is all of those different things can be lumped into how this trust is gonna control it, who gets what, when they get it, all that stuff, yeah.
We've been preparing for a while.
Yeah.
And we've been on a learning curve, because we did deal with the fact that grandfather had a will.
Yeah.
We also had a trust, and he passed away in February. We were dealing with the dementia diagnosis. So
Yeah.
We've learned a lot in 6 months, and this is why
You're learning it the hard way. Yeah, yeah. Yeah, that's, if, rental property is always one of the, because if I had a perfect world, I would have a different LLC for every single property. You're gonna, it's a little expensive that way. But if somebody comes in and they say, hey, I've had this tenant in this house for 20 years, they're great tenants, they're not destroying the house, I'm not as worried about that one as I am the one that you're renting out on Dixon Street, right? I'm worried about that house because there are gonna be some different people coming in there. So, we would work through all of those things in relation to the trust, yeah. Yeah, yeah,
So I'm supposed to be the executor trustee for my parents.
okay.
And I've tried reading the documents that make no sense. So when my parents die, do I go to the attorney who wrote those documents up and say, help me understand what's going on, or, what do I do?
Yeah, it's up to you on if you want to go back to that firm. I would say go to an estate planning firm that knows what the heck those documents mean. I would say your first step would be to have a good idea of what the assets are. Because one of the first, if you come into my office, one of the first things I'm going to ask you is, okay, what are the assets that we're trying to pull together? Did they own these properties? Did they have a bank account? Did the beneficiary on the bank account actually get set up? How's it titled? Right, I'm going to need to know all that stuff. If they've been working with a CPA, you might notify the CPA to go ahead, especially depending on what time of year, right, we're dealing with, because we don't want to get behind on deadlines, right? So that is something we would do. But as far as interpreting the documents, you can go to any, here's how most of my, we call it trust administration, here's how most of my appointments go. You bring me the book, we're going to walk through all that stuff, and I'm going to say, go do these 5 things. When these 5 things are done, let's sit down again, because you're going to get overwhelmed, depending on what the types of assets are, what companies you're dealing with, things like that. So don't panic. That would be my first word of encouragement. There are, we'll get you through it, but hopefully whoever did it was organized. When I do a trust, I include a list of every asset that I know about. Because if something happens to them the next day, I want the kid to be able to go, oh, okay, I know they have a bank account at Arvest and Bank of Fayetteville, and they closed the one at Signature. Because I have called every bank in Fayetteville before trying to figure out where someone had a bank account, and that's not a good time. And you don't want to pay me by the hour to do that either, right? So most of the time, it's people meet, and I say, go do these things. It's not, I also have people come in that slide the book across the table and say, just do it for me, tell me when you want me to come sign as executor, and I'm happy to do that too, because I'm going to bill that by the hour. But don't let yourself get overwhelmed. But start with, okay, what do they have? What are the assets? Let's pull them together, and let me wrap my hands around it, and then that'll help the attorney you're meeting with know what the next steps are. Because that's where I have to start: is how was the asset titled? Did it have a beneficiary designation? Things like that. Yeah. Do you have another one? Yeah.
Yeah, regarding communicating our wishes to our loved ones.
Mhm.
Is it verbally good enough, or should there be some shared documentation?
You mean so like at end of life stuff, or like give me like a specific example about like your wishes?
Healthcare directives.
Yeah.
What's going on with the trust?
Mhm. So I think with healthcare stuff, it's good to talk about. You're going to have those documents in place for the doctor to be able to legally rely on the power of attorney, right? So you could say, oh, well, mom told me that she would not want me to get this medicine. But unless the doctor has that power of attorney in place, because they're trying to avoid a medical malpractice lawsuit, right? So they're going to need to see the piece of paper before they do what you tell them, even if mom told you that's what she'd want, right? With things like a trust, I tell people, and it kind of depends on people's age and stage, but typically, I tell people, tell your kids it's taken care of, that you've done all your planning, give them my card and tell them to call me. Because their heads are going to be spinning when the time comes anyway. And I probably know more about their assets than the kid does, because people keep that close to chest, right? I mean, and it's a generational thing too. So I would say don't overshare on who's getting what and what that stuff looks like, because you're also liable to change your mind. And now you've said one thing, and now you got to go back and update them on what you changed, right? But I think things like, hey, if I get this diagnosis and they try to put me on a vent, don't let them. So that people can advocate for you, but you still need to have those documents in place. I have a lot of clients that I'll meet with. We'll set up the whole thing, we'll get it executed, and then 3 or 4 months later, they'll bring the trustee or the executor in, and we will walk through all of it to make sure that they know, hey, we have these powers of attorney in place. We have, so that they know where to look, but that kind of depends on the situation, right? You don't want to tell people too much prematurely because they start talking at Thanksgiving and they start, it's a rub between kids and all the things. So I think if you can do it in writing, I would do it in writing. And I would have, 2 people that aren't, and 2 disinterested witnesses even sign off on it. Just so they would know, hey, no, this really is what she wanted. But I see videos, I see handwritten notes, I see all kinds of stuff that were really close to the end of life that I can't prove to you weren't done under undue influence, right? So the verbal stuff's a little hard for us to give validity to. You really want to make sure that there's something that in a worst case scenario that we could all stand in front of a judge and go, yeah, no, this is what she wanted, right? And so when you have all these other directives in place and they're signed and they're notarized and they're witnessed and all the things, there's never any question. Okay, I think I had one other one. Yeah.
About 20 years ago, I had a trust put in place, and then a few years ago, I moved here, and then I was doing the purchasing of the house, and I suddenly realized, wait a minute, the documents don't say it's in my trust. And the person, the loan officer thinks that, oh, well, if you want to do that, then you're gonna have to wait
Yeah.
another month in escrow, you're gonna do it later. And I'm
Yeah.
like, okay, so what do I need to do now? Do I need to go to a law office or the bank or the state?
You need to go to a law office. Because typically what happens is, and this is, I don't want to get too in the weeds, but just so you understand what happened in your situation probably, is you had this trust, but a lot of your assets, the things you used when they gave you a loan, were in your personal names. And so when you get to the title company and they go to close on that house, all the documentation has been done in your personal names, not in the trust name, because the trust may not own those assets yet, right? Sometimes the assets go there at death. And so the mortgage company goes, yeah, I don't really want it in the trust name because we based our information off of what's in their personal name, right? So in your situation, probably what I would do, if there's still a mortgage on it, is do what we call a beneficiary deed. And that says we file it against the property now, and it says, hey, at the death of me or me and my spouse, then it dumps to the trust, which will keep it out of probate, and we don't freak out the mortgage company by changing title to it now. Does that make sense? Because you could, if you didn't have a mortgage, we could just deed it from you to your trust. But I either try to get approval ahead of time from a mortgage company to dump it into a trust, or we just do a beneficiary deed so that it goes at death. Think of that beneficiary deed like a beneficiary designation, is kind of how that works. But then the mortgage company doesn't go, oh my gosh, hold on, you moved to the house, because a lot of those mortgages have an acceleration clause that they can call the entire note due if you change title, right? And those are things that some of these attorneys that think they do estate planning don't pay attention to, right? They didn't go read the mortgage on your house, so.
A second question
Yeah.
on top of that, so if something does happen to me and I set this up and then my daughter gets the house, will they have to rewrite the whole mortgage in her name, or will she just be able to take over at that point?
So,
Beneficiary of the beneficiary thing.
yeah, so typically, as long as mortgage companies are getting paid, they don't care, has been my experience in situations like that, right, where we had a death. This is where we would sit down and I would want to know, okay, what was your interest rate? What were things like that? Because if we think your daughter can't get that good of an interest rate, which has been a thing in the last few years, right, because they were so low, then it might be that we go get permission from the mortgage company and we change the mortgage now We would go ahead and move the property into the name of the trust, but we would get the mortgage company's approval, and the mortgage would now be put in the trust name. And that interest rate and all that stuff would stay locked in, right? So then if she inherited it through the trust, nothing changes because the trust would still own the mortgage, or still hold the mortgage, and the interest rate would stay the same. So that's kind of one of those questions where I would have to look at it, I would have to see the mortgage, I'd have to know all the different nuances.
Only 3%.
Yeah.
So I definitely wanted to stay at that.
Yeah, so, do you have a local mortgage company, or is it like a?
Yeah.
Okay, so local mortgage companies are a lot easier to deal with because I can get my hands around their neck, right? If it's like Rocket Mortgage, we're about to have a time. But, so it's worth, right, calling and going, hey, what do y'all need in order for us to transfer this mortgage? Usually it's a letter of instruction, takes them a few weeks to process it. They transfer the mortgage over, they give us permission to transfer the property so that they won't call it the note due, and then it's in your trust and we're good to go. It's just a matter of staying with it and hoping you deal with somebody at the mortgage company that knows up from down, because that's a thing too. But it can be done, is what I'm saying. It's one of those things where we would sit down and really, I've got to see all the angles, know all the details, because sometimes things that you might not think are important are a game changer on what I know about how it's going to work, right? So, but if you have a trust and that house is not in the trust, it needs to be put there. If your trust is done, if I had done it, then you also would have what we call a pour over will, because it pours over into the trust if something had to go through probate, okay? So that the terms of the trust could still control. So with that situation, we wouldn't eliminate probate, but I would eliminate the toothpaste being squeezed out of the tube. Does that make sense? So that's how the will would still kind of come into play with the trust. But you definitely need to meet with somebody. And it can be, I can do it if you want me to, but you need to meet with an attorney, because the bank's probably not gonna help you, and the title company, they're gonna go, oh, I did my job. We made our money and moved on. Okay? Anybody else? We good? Okay, I'll stick around for a little while if you have questions that you don't want to ask in front of the class. Thank you all for coming. I'll flash this up here. So you have my information. There are cards on that back table. You can always email or call. Again, if you feel like you need to meet with me, our consultations are free. You're always going to know if we're going to discuss cost, things like that when we meet. I hope that this was helpful. I hope you learned something. And I don't think she's in here. I was going to thank Kathy. Thank you for helping me back there. Okay, I'll leave this just up on the screen for y'all to get it, and I'll just stick around up here if y'all have questions.